signed a package of bills to counter the Trump administration's immigration enforcement. But we've already heard some pushback from the Department of Homeland Security and other federal leaders. So this morning, I'm joined with immigration attorney Andrew Newcomb, providing more insight on this legislation. Thank you so much for being here.
Thank you, Bianca, for the invitation.
Yes, of course. So this bill package, it was signed by Newsom. It's most notably known for prohibiting some law enforcement officers from wearing masks and hiding their identities. And it's mostly aimed at ICE agents. But recently, we've heard from federal prosecutor U.S. Attorney Bill Essayli that he doesn't think that Newsom's bills are enforceable. So what do you think? Could this lead to another lawsuit possibly between the state of California and the Trump administration?
This is definitely setting up future litigation between the state of California and the federal government. I mean, of course, you have to look at it from the perspective of lawmakers in California responding to their constituents who are rightfully so, feeling terrified and under attack by masked agents. And we've heard stories of people impersonating federal officers. And so it's important to be able to have transparency and to be able to have accountability for those individual officers. And so I think this is a great move in the right direction, but it is likely that, they're going to try to seek an injunction in federal court and try to prevent them from enforcing this law.
Okay, so we have not heard the end of this bill package. You mentioned the constituents. That's the reason why lawmakers have pushed this forward, Democratic lawmakers, that is. And I do want to know, as a practicing immigration attorney, do you find it important that your law offices and some of your clients have access to agents' personal information?
Well, it's important in the broad scheme of things in terms of making sure that law enforcement is having to act within the legal bounds. I think that when you have people that are able to wear masks, it gives them a license to, ignore warrants. I mean, we've seen a lot of videos circulating on social media of ICE agents having confrontations with attorneys, and they feel very emboldened to just kind of move forward with detaining someone in the absence of having a warrant, and having a mask, I think, facilitates them to be able to make those kind of constitutional overreaches. So while it's not necessarily important on a case-by-case basis if my client's already detained, I think that this is important on a more national level.
Yeah, it's interesting that you mentioned that, some of the videos that circulate. I mean, a lot of those raids happening in Los Angeles. We know the Supreme Court voted to allow ICE agents to conduct some immigration raids throughout portions of Southern California based on a person's race, their language, their job or location. So, Attorney Newcomb, I've heard a lot of frenzy, a lot of fear out there after this ruling was carried out. But I do want to clarify here today that this ruling, as of now, it only applies to California's Central District. So that's Los Angeles and some neighboring regions, correct?
That's correct. And so people, there's a lot of hand-wringing and a lot of fear, understandably, about the Supreme Court decision. It's important to clarify what the court did and didn't say. The court did not say the Fourth Amendment no longer exists and you're allowed to racially profile people. What it did say was that the Central District judge exceeded his authority by attempting to curtail the activity of ICE agents, and that what they have to do is continue to review the legality in upcoming court decisions. So it's important to notice that on a case-by-case basis, if you believe or you or someone you know has had your constitutional rights violated, you've been racially profiled, you've been detained without a warrant, you can still bring up those points in immigration court, and it also potentially creates a constitutional challenge as well.
Okay, that's pretty interesting. And I do want to stay with this, though, the Supreme Court's ruling. I mean, eventually, could this possibly set a precedent for lower courts? Right now, like you said, it only applies to some areas in Southern California. But what could this mean in the future when it comes to the entire nation?
So again, it's important to remember that the Fourth Amendment protection against unreasonable search and seizure is still the law of the land. So unless and until there's an amendment to that, essentially what you're going to have is either a class action type of litigation, the way we saw in the birthright citizenship case, which would effectively be able to stop the federal government from being able to use those kind of criteria in making their stops, or individualized challenges. But the idea that, lower courts would all of a sudden adopt an interpretation that people don't have their constitutional rights anymore, I don't see a big risk of that happening. I think, unfortunately, we just have to continue taking this day by day, and I anticipate that there will be future legal challenges.
Thank you so much for breaking all of that down. I know sometimes when we see this come through, people can react very intensely online. So thank you so much for just providing some context to everything that we're seeing. Thank you again, Attorney Newcomb.
Of course. Thanks for having me.
Of course. All right.